or applied to other cases may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transaction or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedure. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may not be redistributed by any recipient.
Top of the pile, so that the judge, like Jack tells you, it's LIFO. Last in. The last thing into the court is going to be the first thing out. Last in, first out. Does that make sense? And it's like so simple, it's unbelievable. Now this guy, he doesn't like that. Because, see, we're over here trying to get on this dang republic. He's trying to bring a republic. This judge is not against me. This judge knows his duty. His duty is public policy and to test and perfect me. If I'm not worthy of passing this test, he's not going to let me. We had that same mom on the young man that went to the mental institution. I was on the phone with her, and she's, it's not fair, Gordon, it's not right. I said, why isn't it fair and right and just? She said, because he's trying really hard. I said, that's the words of a mother. Yes, he's trying for all he's worth. But you see, this judge is like fair, like you can't believe it. All he sees is this. And then when you're tested, if you're going to argue...
Which is the contract. That's all I see is the contract and the negotiations. I can't see anything else. I might like the guy, but if he doesn't contract and settle his case, I can't award anything to him. I'm here to settle the law. I mean the case. I mean the contract.
We talk about this. All of these courts are one thing. Claims courts. The prosecutor came in with a claim.
Which is a charge.
Which is to demand or ask for as rightfully belonging or due to one.
Pay me the debt you owe.
The fiction has a debt. He came in with a claim. Remember the statue that's in many court buildings with the blindfold and the apothecary scale, on the swing arm held aloft. A goddess of law and justice, daughter of Uranus and Gaia. Her name is Themis. Represented as holding aloft a scale for weighing opposing claims. There's a poem we talk about. Remember, we admonish you to substitute contract in the place of the word law. So listen to this poem doing just such. Once law was sitting on the bench. Contract sitting on the bench. Because there's going to be some contract there. A public contract or a private one. If it's a fiction, there is a contract there.
See, the judge said to the defendant, did you get a copy of the contract? I mean a copy of the charging instrument.
Oh, now, here this goes to one thing. He asked him, did he get a copy of the charging instrument? Yes. Now, if our good friend, Prosecutor Richard, just before court started, he takes the charging instrument and he goes, he slides it over to me. Do I have it? I told you, you better not accept these sliders. You go to jail, slide the rule back under, slide the administrative hold paper, get it out of your hands.
Game is hot potato.
There it is. He says it. He's asking him, did he get a copy of the charges? Yeah. How do we know? Because he gave them to him, mailed to him, they came in the mail or something. When they came in the mail, when they got handed to me here, what I'm going to do with these? They're going right back.
If he returns it in the current state, he hasn't really resolved it. So if he's got it and he's got a pen, even though it's only a copy and not the original, he's going to do a full acceptance on the copy and slide it back.
Just
now
my
he's given
signature on the
remedy.
back's full acceptance. I'm just going to say, accepted for value, return for set-off, settlement, and closure. Thanks, brother. I'm not joking. That's exactly, huh?
Do you need to put that on the back, or is your signature?
On the back. If this is a check, how do you endorse a check, right? Don't you, if the check reads like this, don't you turn it this way and put your signature across the top? Pretend this is a check. It just reads like this, right? So you're going to do the same thing.
Turn it over, rotate it 90 degrees,
Rotate it over
sign
and throw your signature on it.
But he was asking, do you just sign it, or do you have to write
Just sign it. You could write it, but I'm just going to endorse it, and I'm going to say, accepted for value, return for set-off, settlement, and closure. Do you have any other charging instrument, brother?
Look at it this way. You got a
Now,
check.
what's he going to tell the judge when he said, did he get a copy of the charges? Well, what does get mean? Did I understand it? Did I get it? I think he got it. He returned them to me, Judge, and he did some gobbledygook on them.
See, when it comes to a check, remember the front side's the public side, the back side's the private side. Who's liable on the check, the endorser or the maker?
Remember, the maker is the one who, the drawer or maker made out the check. The prosecutor
public
made out
side?
the check. He made it out to Gordon
Maker
Hall.
is not liable. Under the Uniform Commercial Code, the endorser, since he endorsed it, he is an endorser, and he's now been made liable on the instrument.
So this is how, if the check bounces, they charge your account for it? Is that
Absolutely. You have never, ever gotten any currency units from anyone in your life. Where did your currency units come from that you've been dealing with in your whole life? You from your signature, and where'd they draw those units? Out of your asset account. You never knew it. If you worked for General Motors and you got a $1,000 paycheck and General Motors gave your straw man $1,000, because a living man does not work for General Motors. Only the vessel, the straw man, works. So they give your straw man a check. You, as a living man, endorse the back of the check for deposit in whose account? The straw man's account in the bank, because you, as a living man, don't have an account. When the check goes into your straw man's account, where do the units come from that make that check good? Your account at the DTC. Did General Motors have any currency to pay you with? No. When the comptroller of General Motors wrote out that check, he said, well, if we had any currency in units, we would be happy to pay this contract off. But since we don't, we're just going to witness that he's entitled to this if there were any units to pay him with. So General Motors is doing nothing more than second witnessing that your straw man's entitled to it, but General Motors doesn't have any commercial energy. They're a fictitious corporation. What's the bottom line on their accounting sheet? What is the net value of General Motors? Zero. If there's any value there, there's a purported value to their stockholder. But every corporation, bottom line on their books is zero, because they're a fiction. They're a nothing. They can't have anything. Okay? So the long and short of it is, your whole life you've been paying yourself without knowing it out of your own asset account. Get that through your head. You are the bank. Nobody else is the bank. They're just the monopoly bank playing the game.
And to keep it real simple, the phrase, my signature is good enough for you to understand, and that's all you really need in this general broad brush. Your signature is the money for you, all right? And returning it is critical, in that you don't keep any kind of anything from them. They'll always come and try and hand you something, because if you've kept it, you're liable for it. When you return it, endorsed, they're liable for it.
Anytime they hand you a piece of paper, they want to get paid. If you keep it, it's evidence you haven't paid it. So are you a debtor now or a creditor? You're a debtor. If you endorse it and hand it back, what's the evidence? You've paid the debt. I no longer hold it.
So can you endorse a warrant?
Absolutely. A warrant in the government is a request for funding.
Request for payment.
We'll play that game later on. We'll send somebody out
Time
to
to
arrest
break.
you, and we'll see what you're going to do.
We got 3 minutes.
Okay?
Okay. let's recap this. We're going to get back into, we want to do some court practice, definitely. And we want to do some arrest practice. But these fundamentals, let's try and keep it. We got 4 doors, and we're not going to argue, and we're not going to make statements, and we're going to make conditional acceptances, and we got a hot potato we're dealing with.
Okay.
So you're going to have a little fun this afternoon.
Let's
we're going to
just
do
bring
some
up somebody. You're the defendant, and the judge has already done with his spiel. How do you plead to this case? Try your best to be Gordon in his response right now. We know you're going to screw it up. Just give it a try.
Now, we're going to get you all in some of these capacities. Matter of fact, why don't you sit down? I need another clerk. Come on up here, clerk. Yeah.
Okay.
You all need to practice a little. I need a judge. Come on up here, Larry, because we're going to start going around. Give me a judge up here. Let's see how he plays.
The defendant right now has the floor. The first practice. You've been charged, sir. You've got a copy of the charges, etc. At this stage of the game, we want to know how you plead today.
I conditionally accept upon presentation of original charging or accusatory instrument
Hold
for
on,
my
Smith,
inspection
here's the
so we can settle this matter now.
What are you, nuts?
You know, that's not a far thing. He could say, what are you, nuts? You've been charged. How do you want to plead?
Which is a question. How are you going to respond to the judge with that one?
You've been charged. How do you want to plead?
I conditionally accept upon presentation of original charging or accusatory instrument for my inspection so we can settle this matter now.
What are you talking about?
Remember, we said his issue is to try to get you to explain. Do you want to answer his question directly, or do you want to demur back onto your issue? Okay, so don't answer his question, or else you become the defendant in his world. So try to think up a conditional acceptance response. You've got to address his issue. He said, would you explain what you're doing? Give us your response.
I conditionally accept your offer to explain upon condition that you provide me with a provisional or original charging or accusatory instrument, settle this matter for my inspection so we can settle this matter now.
Notice what he did. Did he go back to his issue, or did he jump train to go over to the public issue? He stayed on his issue. Good job.
Hold it up. We're not done over here.
Now we're going to give it a try.
Mr. Busher, you seem like a reasonable young man, nice-looking guy, but I'm
Good
wondering
cop.
where you're getting your information.
I conditionally accept my
Now,
providing you
on a
with
serious
information.
note, Mr. Nathan, we just need a little explanation because obviously you've been getting some kind of legal advice from somebody, and the rules of this court are really clear. And if you don't understand the rules here, you're going to get lost in this. And I might suggest that you get an attorney before you hurt yourself.
I conditionally accept your attorney upon presentation of original charging accusatory instrument for my inspection so we can settle this matter now.
Okay, he's staying on the subject, but he's not really addressing the issue. He's not wrong. What would happen if
He is going to stay alive because of that.
Yeah, he is. What would happen if he'd come back and he'd say, I conditionally accept your offer on proof of claim that you're not trying to convert my remedy into some kind of jump the vessel back onto the train so you can deny me my remedy. That would work. You understand?
Or
Because he's coming back to his remedy is, I conditionally accept on proof of claim that you're not delaying these proceedings by obstructing the court, by failing to give me the document to give me the remedy. He could do so many things, but don't answer that question. You see what we're saying? Okay,
Please,
keep going.
please, Mr. Nathan, you really seem like a nice guy. You seem, as a matter of fact, you're obviously very intelligent. Not.
Nice cop.
Or he wouldn't be here. I mean, they'll either try this part or flattery. So let's try a little
Or
bit.
they might go
Now-
bad cop and warn him. They could do either game.
Now we're gonna take a little tougher position.
Okay, I've heard
Mr.
about
Judge, we've
enough.
got to adjourn for lunch or something here, or break pretty soon. So
I've heard about enough, and I've taken all I'm going to take out of you. If I hear that one more time, you will be held in contempt of court.
I conditionally accept your offer that you are not merely demurring my private remedy.
Bailiff,
arrest him.
Okay, now we didn't get into it a whole lot. We're going to close this now with this one statement. When you are now you heard Judge Smith say earlier, I may hold you in contempt. Judge Larry said, I will hold you in contempt if you don't answer my question or you say that one more time. And he didn't say that one more time. He said something else, so he's still safe. But then I'm going to come back one more time and you don't answer me, I'm going to hold you in contempt. Answer him. He did answer him. An answer is a reply. But so that I'm not in contempt, we're going to close it with this. Think about this at lunch. Whenever you are threatened with arrest, contempt, or have the bailiff take you to the ground and sock you up, which isn't going to happen, so that I'm not in contempt of this court, I will say what you tell me to say. I will do what you tell me to do over my objection under threat, duress, and coercion. Judge Smith, whip it on me real quick, and then we're going to lunch.
Okay, understand this. You can't.
No, just do a couple of them with that.
You cannot have a contract under threat, duress, and coercion. Their goal is to obtain a contract from you, so that's the way this game is going. Okay, so I've already warned him, and he's come back. Sir, I am ordering you right now. We're here for the purpose of entering a plea in this case. I want a plea out of you right now. I want yes or no or guilt. I want guilty or not guilty, sir. And if you don't answer me, I will hold you under contempt. Is your plea guilty or not guilty?
So that I'm not in contempt of this court, guilty or not guilty, over my objection under threat, duress, and coercion. He said, you are to answer guilty or not guilty.
Whatever
it's not funny.
He
this
says,
is very dangerous. This is
whatever he said in the quotation is what you're going to
Give
say
me a couple
back.
more.
Sir, you know what I'm asking you, and you're just mocking this court. Now, I'm going to give you 1 second chance here, sir, and I want an answer out of you because you're obstructing this court, wasting time. Are you going to enter the plea of guilty?
So that I'm not in contempt of this court, tell me what you want me to say over my objection under threat, duress, and coercion.
I want you to answer my question. You're either going to plead guilty, not guilty, or no contest.
So that I'm not in contempt of this court, guilty, not guilty, or no contest over my objection under threat, duress, and coercion.
Mr. Bailiff, take this man away. We will continue this matter
I conditionally
till
accept
tomorrow.
to be taken away on presentation of a genuine charging or accusatory instrument for my inspection.
I want him out of my court.
So we can resolve this matter now. Now, I'm not going to pull away. Let go for a second. I'm going to stop. I might be trying to walk out the courtroom this way then, you know.
Okay, I didn't necessarily say he's under arrest. I said I want him out of my courtroom because he's given everybody in the audience way too much reality and information.
Okay, we're breaking. Go ahead. One last question by you, Kevin, and then we're going to lunch, get the mic, and then we're out of here.
So as long as you continue to answer him like you did, he cannot place you under arrest?
No, because he's doing everything I asked him to do.
Hold on. He could remand you to see if you're going to break week, and we'll talk about that after lunch. So this is initial broad brush. There's exceptions to every rule, but we'll talk about it, and you'll find yourself very comfortable, and we're going to test some of you. We got some more court stuff to do. We have a lot of practice at this 2-day session. All of you are going to be up here. All of you are going to play this game. All of you. So just get your mind into it. You're not going to get out of this.
Okay.
And the issue is if you've got clammy palms just playing here, think of what it would be like if it's in reality, because this play role is as close to reality as you're going to get. You're going to have to think like you were in front of a judge. You're going to be put in that process. And believe me, there's no difference between what we're doing here and in the court. If you could do it here, you can do it in the court.
It's not going to be difficult. It seems it at first, but watch how your practice goes. It's like playing hopscotch or anything else. Once we get you a few steps, you're going to go, hell, this ain't hard. It isn't. It's just new. So let's go ahead to lunch.
Okay, Nancy, are we on lunch or are we in break?
We're at break.
Break.
And so
not lunch, break.
Yeah.
We'll
That's
have
worse.
a later
We're
lunch.
jumping ahead just
I'm
a
wanting to
little.
go to lunch.
I know. Well, you can go get a snack because it is 11:52. So if we could reconvene back here or convene at 12:20, that would be fabulous.
Half an hour.
So half an hour.
We'll
so
go for another session, then lunch. We'll come back, and then we'll go to what, about 8 tonight?
It's
and
8
you can
tonight.
have dinner after that
And you have-
for the people at one time. But obviously the people couldn't keep it. So since they couldn't keep it, it's like any other contract.
How does a government under the people come to be? And I'm wondering how the republic itself functioned. A private contract between individuals is clear enough, but how do you get large-scale cooperative ventures going under the republic? How did the government function before the Civil War to have?
It was a republic. It was a representative government of the people. The question was, you know, in the Constitutional Convention, after that happened, the reason for the Constitution Convention was to, quote, create a more perfect government, unquote. The Constitution did not create the government. It was created under the Articles of Confederation and other documents. What is the purpose of a Constitution?
Well, that was a dead-oriented document. That was to
See, if you look up in Black's Law Dictionary, constitutor, don't look up constitution. You'll never find the answer. Under a constitutor, it says one who passes on his debt to a third party. So what was the reason for the Constitution? It was pardon? Yeah, actually, the purpose of the Constitution was to create an Admiralty Maritime government on the national level. Remember, we said earlier that people's word is their bond. But if it's a corporation, an entity, or a person, it doesn't have a bond except that some other third party backs it up with an insurance policy. So remember, the District of Columbia, the national government, was operating internationally, not among the people in the states. And in order for the government in Washington, D.C. to operate under the League of Nations, it needed to have a surety to back up what was going on there, okay? And so literally, it needed the states to underwrite the national government as the insurers. Now, that's not what they told you, because the people basically were ignorant enough they wouldn't go along with it. They needed somebody to back up the national debt. And since the central government was international, they operated in maritime, not common law. See, they don't ordinarily send money payments between nations across the open seas as gold bullion. They use commercial paper to settle accounts. But if you have commercial paper, there's always the possibility of fraud and deceit. So they need an insurance company or insurance as a second backing in case somebody does not perform on their contract. So the purpose of the Constitution was to get the states to back the debts of the national government so the national government could operate in international commerce.
So I've never quite understood what the law of nations is.
It's private international law. That's where you ultimately get your rights recognized. See, like Gordon told you this morning, you don't need the government to guarantee your rights. Your rights are guaranteed by nature, nature's law, and the Creator. The fact that there is constitutional limitations is public policy. But that's not where your rights come from, so that's not what guarantees your rights. You have the right to access private international government maxims of law to show that there's been a pre-agreement among the nations of men that all men are entitled to these rights that are given out. But that means you individually have to be able to understand the procedure and the process to claim those rights under the correct provisions of law. So private international law, once the Constitution got inverted so that the public now became nothing more than a restatement of military government, the public assumes that you're going to operate as a maritime vessel to do your commerce. That's why they gave you a straw man. Your straw man is your vessel to operate on. And on private international commerce under the law of the sea, they've given you the tools you need to function. The patriots immediately object to that and say, well, our nation was created under the law of the land. We don't need a vessel. We can exist as a living man or woman. But remember, Hollywood is always telling you the truth. In Kevin Costner's Waterworld, told you there's a presumption today that land exists somewhere, in other words, the common law. But according to the principles of the mariners, that's only a rumor that law exists on the land, that everybody is functioning on the high seas, and that there is no land anywhere. So now what you have is the public is actually believing this and upholding that. For instance, the geodesic survey of the land is conducted by the Coast Guard. What? And what does the Army have a mission to do? Dredge the harbors for the Navy. Are you getting the picture that everything's backwards and upside down here?
But does it
Because
really
we're
matter?
under the law of the sea instead of the law of the land. Now you can object that, argue it, and fight it all you want. It isn't going to change the precept upon which everybody's operating. So you have to get your remedy styled through the presumption of the law of the sea, which is what those public courts are, but you're still maintaining the maxims and the remedy of law of the land if you know where to go get it. And in that movie that dealt with Waterworld, remember there was a little girl that everybody was trying to locate. The little girl represents God's church. And what was it that she had that all the mariners were seeking? A map to tell you where the land is. In essence, she had the remedy that we're giving you to go back to your remedies of the Republic in order to put in shape your remedies coming from the law of the land, and then you've got to translate those remedies into the law of the sea and make them appear in the public maritime courts in order to get your ultimate remedy.
And isn't this a beautiful game? It's merely just contract law. You know, what about who wants the common law? Who wants this law or that law? How about
The law condemns you.
How about just straight contract law, and you get to be and do and make it whatever you want? It doesn't get better than this. It's not a bad thing. It's the best. It's merchant law. That's how you conduct commerce. You have to, and this law has existed for thousands of years. This same stuff we're dealing with now with some changes for the modern day communications and things like that, or addendums there too. So let's have some fun and learn how to play. It's not a hard game to play. It's just merely offer and acceptance and what constitutes agreement.
See,
it's that simple.
The sons of Cain have done in the secular law world exactly what God put out for you in the spiritual law world. In the spiritual law world, do any of us as sinners, I mean debtors, have a remedy to get rid of our debt in and of ourselves? The answer is no. So what do you have to do to get a remedy in that spiritual world? You have to go to an accommodation party who's a creditor that has the currency to pay off the debt, i.e. the Savior. Okay? In the secular world, they made all you guys sinners. I mean, your straw man is a debtor, right? Does your straw man have any access to any asset currency to pay off the debt in the secular world? No. So what do you have to do for a remedy? You've got to find a Savior that is not in the world of the secular debt. Who is not in the world of the secular debt? The living man or woman.
You.
You are the accommodation party. You are the Savior for your own straw man. And so these people, you might call them brilliant. You might call them incredibly smart. All they're doing is copying the Scripture. And whereas God put you in a world of spiritual debt and told you you had no remedy except to go to the creditor, they're doing the same thing to you in the secular world. In 1933, they took away your remedy in their world, and you got to go to an accommodation party from another world, which is the living man or woman, to get your remedy. That's all it is.
Which would you rather have? Pre-33 where you had to pay the debt, or post-33 where your signature pays the debt? It just gets better, you know? I mean, look at the bright side of this. That's not a joke. You absolutely have got it made. Never has it been so beautiful as it is today. We got iPhones in the world, and we got conferences. It doesn't get better than this. We're not riding horseback six days to get to this conference from Arizona. This is the time we've all waited for.
There's patriot gurus out there that tell you the government's wrong and do everything bad, and they can fill up an auditorium because everybody wants to believe them. But all of their remedies are on the moon. They're not working. And the reason they're not working is they haven't gotten to reality. Gordon and I come along and say, doesn't Scripture say you got into sin from the get-go and you have no remedy to get out of it? But the good news is you don't have to pay off the debt because there's a free payment coming from your brother, the Savior, that's paying off your debt, and you don't even have to pay it. All you got to do is go to your brother and ask for the remedy. It's that easy. Gordon and I say to our students, look, you got the ability to move your hand and sign the name to a piece of paper, don't you? And if the answer is yes, you got your remedy. Doesn't Scripture say, basically, you weren't sold into slavery for money, and you don't have to come up with substance money to get bought back out of slavery. It's all nothing more than a monopoly game. But since the answer seems so simple, we get like 20 people that show up at a seminar because obviously that's too simple to work. The biggest problem we have is getting our students to understand in their mind that we're giving you something that is a substantive remedy. And literally it costs you nothing except to wrap your mind around what it is we're telling you.
Now,
most people can't deal with that.
You're going to find that we say a lot of things, and they sound good. Somebody emailed me the other day a Latin saying something along the line, if you don't read it, you don't believe it. It was something to that effect, and I'm going to tell you that if you don't crack a contract book and a few other books to verify some of this, you're going to have a hard time really believing it the first time a little wind comes up, a little water comes under your foundation if it's not set in bedrock. You can go to these contract books, Brian Blum Restatement. Brian Blum's book will tell you in the beginning, the study, if we tell you the game is contract law, is it merely then just a study of the rules? No. It necessarily requires careful thought about underlying policy, legal philosophy, legal process, and historical perspective. That means you got to open up a book. Just like we talk about the mailbox rule. It's deemed received. The court receives something when it's put in the mail properly. Not when they get it. And so we just had a gal the other day that was supposed to be sentenced on Thursday. She went up to her cabin in Flagstaff from Arizona, got snowed in, and called the
Court clerk.
Court clerk. We're going to call her and see if we can get her on, because she's our friend Susie, who's dealing with a very interesting deal, and you got to hear this, because this offer and acceptance game is still not quite coming home to Susie, but it might help you, because she's up in the mountains, snowed in, and she can't come down to sentencing, and you know how that's going to go over.
Physically impossible. You're not going to make your appearance.
Do you think there's going to be an arrest warrant out for her for that? Are you sure? Cost many a man life or fortune for not knowing what he thought he was sure of. Very good. We don't know. You're going to hear an interchange. Remember, we told you, everything is offer and acceptance. Didn't we say that? Let's see if we can get Susie on and see if we can make it heard from this, all right? This would be really a lot of fun if we've got her voice, because she's really cool on this. It's got a red. Red is on? Red.
Hello?
Susie,
Yes.
I'm going to try and put you on the speaker here. We got a little audience here. Say something.
Something.
Can you all hear that?
Better.
Okay. I'm going to repeat her words. She said something. Okay. Susie, you were up in the mountains the other day. You had a problem with showing up to a sentencing for the straw woman. Susie, you made a phone call to the clerk of the court about, what, 3 or 4 hours before the sentencing was to take place?
Yes, I woke up that
Can you
morning.
hear this?
Hang on just a second. I got to get the telephone to somebody.
How? It is on speaker.
The phone is ringing. What? Okay, I woke up that morning and it was snowing, and we've been totally snowed in overnight. And so I called the
Can you hear this?
and told them that I wouldn't be able to make it in. I talked to the
Hold on a second. What?
clerk.
You got it? Go grab it. Yeah, I know what you're talking about. Yeah, there's one of those. Yeah. Yeah, somebody brought me one of those. Hang on, Susie.
Tell Susie we're going to get something to hook up.
I'm going to get something to hook up this phone so we can get loud, because this would be good for everybody to hear. Because we're talking about offer and acceptance in this game, and I'm hoping that you, Susie, have come to an understanding of offer and acceptance based on what happened to you the other day. Because I asked everybody, what happens if you don't show up to a sentencing? Well, we got to finish the thing. What happens if you don't show up to a sentencing and you've made no call to the clerk of the court or made any agreement to the contrary? Will there be an arrest warrant for the straw person? Absolutely. What if you don't show up to the hearing, but you communicated with the clerk of the court in a dialogue back and forth and renegotiated the position under an act of God beyond your ability to be there? But that isn't going to keep him from saying and doing, because you see, no matter what happens, she is still the real person. Now that's an amplifier. All right, we got something coming here in a sec, Susie. It's going to be really good. So I thought they were going to bring me a little box. I don't got a little box. I got a box. Let's put it right up here on the table. This looks like a boom box for a ghetto blaster here. Let's put it up here. Hello? Oh.
Oh, wow.
Where's your volume on this? Now we need this.
Okay, Susie. We got you on a boom box now. All right. Tell us what happened.
Okay, let me speak and see if it's echoing in my ear here for a minute.
Can you all hear this?
Yeah, it might be up a little too loud, because it's echoing back in my ear.
Are you ready, Susie?
Yes, it's echoing back in my ear, though, so it's kind of confusing for me to talk.
Well, try and talk and ignore the echo. It doesn't echo for us, but I understand why it's echoing for you, so try.
All right. Well, what happened is I was supposed to show up on December.
Susie? This is getting ridiculous. No, this is worth listening.
That isn't the problem, Cannon. That's not the problem. It's the microphone on the phone.
What happened?
Okay, my bad. Can you hear us okay?
Yes.
Can you all hear Susie? Okay, tell us the story, Susie.
Did you hear any of it, or should I start from the top?
Start from the top. Give us a little background.
All right. My friend and I had left the valley and came up into the mountains, and it was a nice, bright, sunny 70-degree day. We had spent 2 days almost up here and fixing some repairs, and it was really like nice and shiny and sunny. So we went to bed on the 30th, and we were planning on coming down. I had packed up everything. We were going to leave on the 1st and go back down to my court date, which was in the afternoon. Upon awakening on the 1st, we were snowed in. The snow came in the evening, and it just like bombarded us, and it's still bombarding us. So I called the clerk, and I asked her if I could get an extension that I was snowed in.
Now hold up, Susie.
And
I want everybody to picture in your mind offer, counteroffer, 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 back and forth, okay? Remember, nothing is stronger than contract law. Now, she couldn't have said, I'm proof of claim, I got money for gas to come down. That's within her power. But when it's something like an act of God, listen to this dissertation. Go ahead.
Okay, so I called in to the clerk, and I told her that I needed an extension because we were snowed in because it just came upon us unexpectedly. And I needed the extension for me another day. And she says, well, I can't give you an extension. She says, you have to put that motion into the court. And I said, well, there's no way I can put it into the court because I can't get out of here to go even to the mailbox to put it into the court.
Well, hold it up, Susie. Susie, didn't she first tell you, I'm stuck in the mountains? She didn't say, you have to be here or something to that effect?
Yeah, I'm getting to that. Yeah, she said, well, we don't care. You've got a court date and you have to be here. And I said, well, it's impossible for me to get out of here. So what do you suggest I do? And she says, well, you have to put a motion into the court. And I said, I can't get a motion into the court because I can't get to the post office, and I can't get to the court to put it in. So she said, well, that's not our fault. We don't care. You have to get it in here. And I said, well, perhaps I can get a hold of my notary who is down there, and I can have him put a motion in for me. She says, no, we won't accept that. It has to be your original signature and blah, 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 blah. And I said, well, I'm telling you, I might be talking funny because it's blowing back in my ear and I can't really hear what I'm saying clearly. So I hope it's coming through okay.
It is.
But at any rate, she says, well, that's not our problem. You have a court date today at 2 o'clock and you had better be here. And I says, well, I'm telling you right now, I cannot make it. I am snowed in. And so she says, well, that's not our problem. You better be here. And I said, well, I will try to get a motion in somehow, but I don't know how I can do it. And I just hung up with her then. And then she called me back a little bit later and said, I checked a city called Cottonwood, where my notary is. And she says, I checked that, and there's no snow there.
She says, I checked the weather.
What was that?
She told you she had checked the weather.
Yeah, she had checked the weather in Cottonwood, and there's no snow there. And so I said, I'm not in Cottonwood. And she said, well, where are you at? And I said, I'm in Flagstaff. And so she said, well, hold on just a minute. So she must have gone and talked to the judge.
Or checked the weather.
2 minutes later, she came back and she said, I'm checking and opening in the docket. So she said, hold on. And I said, okay. And so then a few minutes later, she came back and she said, well, we are rescheduling your court date to the 5th at 3 o'clock. And you had better be there. Okay, thank you.
You know, the neat thing about this is she calls up and she says, I can't make it, and the gal says, well, you have to be here. You have a court date. Offer, counteroffer. Well, I can't make it. Counteroffer. Well, you have to make it. Counteroffer. I can't make it. I'm snowed in. Counteroffer. Well, I checked the weather. It's not snowing in Cottonwood. I'm not in Cottonwood. I'm in Flagstaff. Counteroffer. Not exactly the smoothest interchange, but in this kind of a situation, it's effective and will work. You don't have to say, I conditionally accept on proof of claim this. You can become a little more relaxed. And in Susie's case, and what we're trying to get across to all of you is, much like that, when Susie goes in for her straw person, I'd like her to quit saying she has a court date, because the straw person has a court date for Monday at 3 o'clock. What does 3 stand for, Jack?
3 is the church.
So,
It's God's people.
So Susie's going to be there, barring anything unforeseen, at 3 o'clock on Monday to take care of the straw woman's business. Can you tell me your mantra for coming into court, Susie? You're going to be standing there, and the prosecutor's going to introduce, and you'll be standing, and you're going to introduce. What are you going to say?
I am going to, hang on so I don't embarrass myself.
It's perfectly, and by the way, ladies and gentlemen, it's perfectly okay to have your notes in court. And you can read from them. It's much better if you have it memorized. But it's perfectly okay to read from them. So go ahead, Susie. Tell us what you're going to come in and let's see if you're ready. We're going to have a little fun with you.
Oh, thanks. I'm going to say, let the record show I conditionally accept these proceedings today on further claim that I am not here today as the paramount security interest holder in all property and collateral, both registered and unregistered, belonging to the defendant, Janice Taylor, appearing especially, not generally, as the accommodation party, merely for the purpose to continue the public proceedings.
Susie, I'm going to help you here. And I don't know why you can't write down what we've gone down, because we spoke to you many hours ago and you still don't have your mantra written down. So, I'm not sure what excuse you could possibly give, but merely for the purpose to continue these public proceedings for 30 days, because that's what she's asking for. You can't just leave it open. For 30 days, and you could say pending completion of the private administrative process, so we can resolve the matter so that procedural and substantive due process and equal protection under the law is applied. Now, Susie, let's say you said that, and the judge says, excuse me, we're not here for that. You had your opportunity, Mrs. Taylor. You didn't make the sentencing on Thursday. You gave us some excuse about the snow, and we checked, and it wasn't even snowing. Notice I just want an argument out of her, and she's a sucker, so she's probably going to say, but it was snowing, when her real issue is something else. But it wasn't snowing, so I'm really highly suspect, but it doesn't really matter because we're going on to sentencing anyway. Because you lied then, you've lied before, and I'm not going to be putting up with any more of your crap. Do you understand me? Now what are you going to say?
I conditionally accept the offer upon proof of claim if they're not a request before the court to continue the public proceedings pending completion of the start of the private administrative process. Are you talking to me? It's coming back in my ear. I can't tell whether you're talking or it's me.
It's you, and you're doing good. But essentially, remember, you got to put the 30 days in there, so at least you're on track that way. Very good. Congratulations. Because I usually can get her to join an argument, ladies and gentlemen. So normally she's off on some tangent and thinking about what I'm saying when it doesn't matter what I, as the judge, say to her. Her response is, I conditionally accept the offer on proof of claim is there not a request before the court to continue these public proceedings for 30 days, pending completion of the start of the ongoing private administrative process? When completed, won't have a good likelihood to resolve this matter so that valuable public resources are not wasted, and I'd like her to throw in, and so that substantive and procedural due process and equal protection under the law is applied. And then, therefore, my business here will be concluded. Now, what did I tell you has to be added on, ladies and gentlemen? Your call to action. Therefore, I now move this court to continue the public proceedings in accordance with the record or the motion before the court. And the court is me and the prosecutor. I asked the prosecutor, that's the motion. What's the judge going to say to that? A lot. He could say 100 things, 1,000 things, but none of them matter until they prove to me there isn't that request before the court, and it is. So there's nothing they can do. I might say, Mrs. Taylor, or I might turn to the prosecutor, Mr. Smith. Do you agree with this?
I'd come back and say, absolutely, Judge, she had a trial. She's been found guilty on all of these issues. The United States doesn't want to tolerate any more harassment, wasting of time. That's all that's going on here. She was found guilty in a trial. She owes this. And at this time, I believe we ought to sentence her. She's just trying to obstruct the sentencing.
Do you hear that, Susie? You're trying to obstruct the sentencing and everything else. What do you got to say to that?
Upon proof of claim, is there not a request to continue these public proceedings on this matter? Is there any record for opposition to that there's a travel to say?
Okay, Susie, we can't hear you, but you're on the right track. I could do a couple of things. The safest one for Susie to do, I conditionally accept the offer on proof of claim. Is there not a request before the court, blah, 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 blah. And on proof of claim, is there any record writing in opposition to the record that is before the court?
That's what I said.
Well, there's that, and going back to your issue and make sure that you have your call to action again. So you could start and say, on proof of claim, that there's any record in opposition to the record that is before the court, and on proof of claim, is there not a request before the court to continue the public proceedings for 30 days, blah, 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 blah. Therefore, I now move this court to continue these public proceedings, because you have to remember, this is what's up, LIFO, last in, first out. This is what this judge is going to be stuck with if you can hold it. That's the contract. Because contracts are evaluated objectively. Outside of your 9, not what you think and not what the prosecutor's now saying and not what Susie's saying. She keeps bringing up that stupid thing. Isn't there a request before the court? Just show me that there's not a request before the court, the thing she submitted and sitting there. You just show me you ain't got that piece of paper, Judge. He can't prove anything. Is he going to deny it? He can't. He's not stupid. He'll say all sorts of stuff because his goal is just to get her to argue. You're doing 10 times better than you've yet done, Susie, because you keep coming back to the issue. Make sure you get your call to action in. Thank you, darling.
And Susie needs to put in a paper for that Monday hearing.
Susie.
Yes?
Have you put in didn't we put in a conditional acceptance that is, yeah, we already did,
For
Jack.
the Monday hearing?
For the hearing. We already put
Since
in a
it's been
conditional
delayed.
acceptance that is merely for the purpose to continue, and it's not meant for harassment, delay, and all that. That's what we put in yesterday, right, Susie?
Yes, we did. And then
Good.
I got a letter from them that I don't know where it came from. It just snuck up from the prosecutor that put one in there about the supplemental PSL.
Hold it. I'm having trouble hearing you a second. Let me get this. Hello?
If the prosecutor's got something in on top
Hold
of
it.
hers,
Susie?
she's got to come back.
Yes.
Are you telling me that after you put that in, you subsequently received something from somebody?
Yes, it probably crossed in the mail.
No. If you put yours in last night, then yours is not, they didn't send it to you subsequent.
Yours was dated December 1st.
And what is yours dated?
Mine is December 1st also.
Let me ask you this. What does it say?
The prosecutor put in a document saying that since I had not replied to the PSR, that I must be in agreement with all of the figures and everything that they had put in there about what I owed, basically.
Let me ask you. She said, did you all hear that? She received a PSR. That's a pre-sentence report. Are you telling me you didn't answer that and send it back, yes or no?
I have to check. Yes, we did a conditional acceptance.
Okay, hold it up. You did a conditional acceptance to the PSR report previously?
That was the first one. Now they came back with this second one.
All right.
Since I did not object to it,
okay.
I must be in agreement with it.
Hold on a second. What was your conditional acceptance to the PSR report before? Do you remember? Or do you have it there?
I don't have this, but hang on.
Do you remember what we told her to say, Smith?
Should have said it was moot pending the outcome of her process, but...
All right, hold on a second. Let's all hear. Susie, are you listening?
What I did was 4 constructive notices of conditional acceptance. The one was to the pre-sentence investigation report. The other one was for the government.
Tell me, Susie, tell me the one with the PSIR report said.
Okay, hang on a minute.
Can you all hear this?
Okay. I conditionally accept the pre-sentencing investigation report received on da-da-da from da-da-da, offer number 2, herein, upon proof of claim that, and I put my name, is not the paramount security interest holder in all property and collateral, both registered and unregistered, belonging to Janice B. Taylor, and has not entered into the record a process to continue the public proceedings for 60 days, because this was, way back before, pending completion of the start of the ongoing private administrative process, when complete and certified as a record by the Secretary of State of the State of Arizona, and a second process with the attorneys which won't have a good likelihood to resolve this matter. See attached exhibits A, B, C, and D.
Okay. So we got in a conditional acceptance on proof of claim that our private administrative record, when completed and certified, won't have a good likelihood to resolve the matter, making the offer moot. Now, I don't know if you got the moot. So now, you received more than one PSIR report, I'm thinking. Did you? Yes or no?
No, only one.
So,
But there was a first witness. She needs a second witness.
okay, there's...
So
here,
she should respond again.
Of course. And she should respond in what, Smith?
Conditional acceptance again on proof of claim that the private administrative process
Identical.
will not make their offer that the PSR report has anything to do with this thing moot. She's not arguing against the PSR, otherwise an argument is a dishonor. She's saying, let my process go forward, and that whole issue is immaterial and irrelevant.
Let me tell you what's going to be very important, and you better put this together today, and you better plan on filing it Monday morning. If you can get it in the mail with your guy again today, and then take a copy showing that your notary put it in the mail today or tomorrow, I don't care which, it makes no difference. But it's going to be a conditional acceptance. Now, they emailed you that, correct?
No, they mailed it.
All right, then you're going to make sure you're going to have to mail that in the envelope back, and you're going to conditionally accept that on proof of claim that the private administrative process a copy attached here to and incorporated herein by reference as exhibit, whatever you call it, when completed and certified as a record by the Secretary of State, State of Arizona, won't have a good likelihood to resolve the matter, making the offer moot.
She has to do that to get the last one in, because remember, when the used car
Hold on. Jack,
when the used car salesman
speak into that so she can hear.
When the used car salesman says, but this is really a beautiful car, I know you've rejected my offer to sell it to you in the past, but you really need this car, and so I'm making the offer again. Remember, Scripture says it takes 2 or more witnesses to everything. So just because she responded to the first offer and rejected it does not mean she can ignore the second offer, because the second offer is the last in. It will be the first out.
Let me ask this, Smith. Can she ignore any offer?
No.
That's right, ladies and gentlemen. You cannot ignore any offer. Now, why would, if the straw woman's been found guilty, everything's done, why are we now talking about a hey, if you agree with this PSR, what has all that got to do? I thought we just got a simple thing left to sentencing. It's never over till it's over, and it's not ever over. Contracts
They need
move.
2 witnesses. The judgment was 1. Now the PSR report is the second offer. If you act as a debtor on both, you have certified that I will play the role of the debtor, and you're going to go to prison.
So, Susie, to save your life, you have to get that conditional acceptance in, form it after the other one. It's only regarding the receipt of this letter. You're going to put the letter back in. You know who it goes to. Your notary's got to send it. Notary, and then a notice to the court of it, and get that in the mail. And you can fax it too.
Take a physical copy to the hearing on Monday in case they got nothing.
I'm just telling you that you may go ahead and email it with all your conditional acceptances, signatures, notary certificate of service, and you better take a hard copy in with you to deliver to the court. And you're doing a real good job with your mantra. And the only way you're going to come off on proof of claim is there not a request before the court to continue the public proceedings for 30 days, blah, 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 is if you get threatened with a contempt or an arrest if you answer that way one more time. Or if you don't, if you don't just tell me, if you don't allocute, then I'm just going to go ahead and pass sentence anyway. And okay, what are you going to say to that one? If you don't want to make an allocution, Mrs. Taylor, that's fine. I'm going to go ahead and sentence you anyway. What are you now going to say to that one? Because that's a kind of different, isn't it?
Yeah. Would I come back with I conditionally accept upon proof of claim that there is not a request before the court?
Oh, you're not doing half bad. It's no different, darling. I'm just trying to trick you. It's no different. You're doing better. On proof of claim, is there not a request before the court, blah, 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 blah. You can do whatever you want if you can just prove to me there's no request before the court to continue the public proceedings for 30 days. Blah, 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 blah. Finish your stuff and get off with your demand or your call to action. Therefore, I move this court to continue these public proceedings for 30 days in accordance with the record before the court. And my business here is concluded. Have a nice day. I'm walking out of there. They're going to, after 2 or 3 of those, I move this court and they keep stalling around and my business is concluded. You better be leaving. And then if the judge says, if you leave, I'm going to have you arrested. Well, okay. So that I'm not arrested, I'll say what you tell me to say, do what you tell me to do over my objection under threat, duress, and coercion. Party's over. There's nothing he can do. And then he's going to come up with some weird excuse about sentencing, or I'm going to have a mental competency exam done, or I'm going to have something, and you better have yourself back in here, and I'm going to, the psychologists are going to be contacting you, and we're going to adjourn this hearing or whatever. It's going to be an interesting one on Monday. So you're getting the idea. I think you listened this morning. I got to congratulate you. It's only taken me 3 weeks to get you there.
Hey, I'm a guinea pig.
No, you're not a guinea pig. All righty. Thank you so much for sharing with us. We appreciate it. We're not here to embarrass you, but real life stories help everybody. And if you can do it, these other people can do it, and you're doing it, Susie. You're really listening. You got it. Is there not I conditionally accept the offer on proof of claim? Is there not a request before the court?
Right. Now, on answering this one back, do I have to send all of that A and B process, or just since I've already sent it about 1,000 times?
It's going to be 1,001 times because you're conditionally accepting on proof of claim. Remember, last in, first out. The only thing up is what's there. I don't care about the foot thick of other stuff that it was sent. All the judge is going to see on proof of claim that the private administrative process, a copy attached here to and incorporated herein by reference as exhibit, whatever it is, won't have a good likelihood. And because you just did your notice of fault the other day, he sees progress. You can look forward to success, but all he can see is what was up there. You can't say, remember, I already put that in. Now you're explaining. The only thing he can see is what's on his desk, the last thing in. So you have to put it, yes.
Okay, I got it.
Very good. Have a nice day.
Oh, I'm gonna.
No, you're doing very good. If you can just do nothing but get that mantra, and I don't care if you got to read it. It doesn't hurt to read. But you know what? What if you just do it 1,000 times? You have till Monday at 3. You should be able to reel this off like anything, because you'll know it. I conditionally accept these proceedings on proof of claim. I'm not here today as the paramount security. You show me I'm not here as a paramount security interest holder. Do you think he can do that? He can only say he can only say like hell you are. You're the frickin' defendant. You've been in my courtroom 100 times. I know you. You've been here, so quit playing games with me. Now what are you going to say?
Unconditionally on proof of claim that there is not a
on proof of claim, no, not there is. On proof of claim, is there not?
Is there not? Yes.
On proof of claim, is there not a request before the court, blah, 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 blah. I don't care what he says, except when it comes to contempt. Excuse me, Mrs. What is your name? You did it last time. Just refer to me as accommodation party. Is there not a request before this court, blah, blah, blah. I now move this court, blah. You just go roll right into your deal.
Okay.
On proof of claim that I'm not here, what's your name? On proof of claim that I'm not here in the capacity and for the purpose previously stated, and blah, 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 blah. Is there not a request before the court, blah, blah, blah. Therefore, my business, blah, blah, blah. You're done. What's he going to do? Don't come off it. You better hold on to that like you're holding on to a parachute after you came out of an airplane and ain't strapped on your back. A death grip. Because if you don't, you're going to make our work a lot harder.
I got it. I don't want
sometimes they say an ounce of prevention is worth a pound of cure. In her case, an ounce of prevention, doing it right the first time, will equal about 13 tons of cure, because if they drag her into jail, it's going to be a lot of work to get her out, and she's going to be right back at having to say some kind of mantra again. And why would I think she can get that when we've been doing this for, although not very long, 3 weeks, but, I'm pulling my hair out trying to get Susie there. And I don't have much hair to be pulling.
You've done a good job, and I commend you. You've done a good job.
All righty, girl. Do good. We're counting on you. There's a whole bunch of people here going to be wondering, what happened to Susie on Monday? I'm telling you.
Right.
And they're all going to be asking our people, what happened? And I'm going to be inundated. And if I got to be embarrassed and say, she gave it up, they're going to go, oh, my gosh. I'm going to say it's what she wanted. Every man is where he is by the law of his being. The thoughts which he has built into his character brought him there. You only have to memorize this and put that part in we talked about. And on proof of claim, we got that due process, equal protection clause in there. Write that thing out and study it over and over. And Ronnie, make sure your boyfriend just drills you, grills you, and beats you about the head and shoulders with it. And have your notes with you and be able to hold to it. And it wouldn't matter if I had conditional acceptance. Is there not? You can get away with, is there not a request before the court? If there wasn't a request, I'm going to sentence you. If there wasn't a request before the court, blah, 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 you could. But since there is, I don't know what you're going to do about that one, Judge. He's going to try as is his right. And you're going to try as is your right. This is the best game on the planet. Very invigorating. And emotional? Oh.
Gordon, Ron wanted me to ask you about somewhere we have heard that there is a... why don't you ask him?
Gordon, back when I was a cop, and they were in court, when they're questioning a person like that, and she's pressing them to see if they can hold their mud, it seems to me like those judges can only do it 3 times on each issue before he has to yield.
Or move on.
Well, generally speaking, just like our friend Dr. Don, when he said his mantra 3 times, see, the judge could see that Dr. Don wasn't giving it up. No matter what he said, Don was just instantaneous with the, on proof of claim, is there not a request before the court to either 1, discharge the collateral, or 2, for the moving party to appear and present any genuine charging accusatory instrument for my inspection, therefore my business concluded, I now move this court, blah, blah, blah. He said it 3 times. When he started on the 4th, the judge bolted from the courtroom. In that sense, you're not wrong, because just like Jack said, out of the mouth of 2 or 3 witnesses, if Susie's very firm and very confident and does not waver, because he's going to come up with all sorts of stuff, like he did Dr. Don a few times before that. He said, Dr. Don, my podiatrist is Jim Smith. He's the head of the podiatry. Do you know him? And Dr. Don, oh, yeah, I know him. He's a real nice guy. And they just had this conversation. They had a discussion. Did you come to do your business or didn't you? I could see right now the judge going, well, Mrs. Taylor, I saw that last Thursday you didn't make it here because it was snowing up there. How much snow did they have up there? What is your comments, Susie, after you've done your introduction? He says, well, like how many inches of snow did they get, Mrs. Taylor?
I conditionally accept your offer upon proof of claim. Da-da-da.
That's right. On proof of claim, is there not a request before? I didn't come to talk about snow. I didn't talk about anything. I can picture him doing all sorts of stuff. He's apt to say to our gal here, you didn't make it to the hearing last Thursday, and that was unacceptable, and it wasn't snowing where you were. I don't even know if it was snowing there. I got a feeling you were lying just to get out of this. Now what are you going to say?
Could I say something like this? I conditionally accept your opinion upon proof of claim that there is a recording or a request before this court for your inspection. I'll go ahead with my mantra, but could I say something like that in the front of it?
Sure you could. You could say all sorts of shit.
Okay.
You know, I thought you were going to do pretty good, but we all just got a sample of, and this, you know, this is classic, because this is what the judge is going to do. He is going to find some little string on your coat to worry it loose and unravel you. That's exactly what he's going to do, because you think, well, can't I just say something? What the frick, you want to say anything but excuse me? I can't. Is there not a request before this court to continue the proceedings? He's going to want to talk about your mother and your carbuncles and did you have an operation when you're 7 years old? He's going to find, I don't know how they do this.
It sounds like the toothpick question. Well, how much snow was there?
It's the toothpick question. How much snow was there? Go ahead and get off of your thing and see what happens to you, ladies and gentlemen.
If you can answer one question in his jurisdiction, he's got you.
Hold on. Susie, what do you mean? You exactly were trying to get off of this. Can't I say this? Yeah, if you want to go to hell in a handbasket. You there?
Well, what I mean is you said, excuse me. Well, instead of me saying, excuse me, I could say, and I'm not really talking back to him. I'm not engaging in his conversation other than to say, I conditionally accept your opinion. However, isn't there or do I just not say anything about what he's talking about and just go right on with my mantra?
I'll tell you what. Let's do that, Smith.
Excuse me.
Well,
Excuse me.
Mrs. Taylor, my opinion happens to be pretty fucking important here at this hearing today. And I don't appreciate you assaulting my intelligence. Is that what you're trying to do, Mrs. Taylor? Because I'm going to tell you right now, I can have your ass arrested. You think you're some smart ass or something? And don't give me a bunch of crap. Do you understand my question? Are you a smart ass, ma'am? You better answer me, because I'm going to have you arrested.
Excuse me, is there not a request before the court to continue this meeting for...
I don't even care about that, ma'am. I got a question for you. No, excuse me. You opened up the question. Now you're going to deal with it. You're not going to get off track again. You opened it up. You have a duty now to do this. Now tell me, you think you're some kind of smart ass?
I get you.
Oh, very good. I'm going to tell you, when a judge attacks you like that on some kind of a thing where you opened the door, you're going to rue the day you didn't just say, why didn't I stay with my mantra? What was with me? Like I think your opinion's important, Judge. Like your opinion matters. And is there not a request? Oh, that'll do. That's going to work real good. I don't know what I have to do to say, choke you into submission here, woman. Ronnie, are you there? Ronnie.
No, he's outside.
Well, he's an ex-cop. Tell him I said put an arm bar in your throat and try and get you to understand this. All righty, Susie. Do good, girl. No, you got to stay with your mantra unless the guy's going to threaten you with contempt and then all the rules go out. And if the contempt lifts, you go right back to your mantra. Or if they adjourn it, if they adjourn that hearing for 15 minutes, they do that. Then they come back. And all bets are off. You got to reintroduce and all sorts of stuff again. They're real tricky. Unless you know how to just be a mindless myrmidon and do what I told you to do to save your life. Most of you just won't do it.
I'm just going to be a blubbering idiot. That's it.
No, why don't you just be a repetitive creditor who knows what they're there for? Not a blubbering idiot, a repetitive creditor who knows, hey, you got my money or don't you? Look, the dog's sick. You got my money. My mom's sick. My dad's sick. The kids all broke their backs this week. I just want to know, you got my money. Can you stick on your mantra to save your life? And then, here's another one, ladies and gentlemen. What are you going to do if they say, remand her to custody? Now, you better speak up and do a conditional acceptance on proof of claim. They're not denying your right to due process and equal protection under the law, incurring personal liability or something. You can do that, or just simply get your mantra, because they're very apt and they don't not do this. It wouldn't be unlike the judge in some of these cases to remand you into custody just to see if they could rattle you loose. And then we just had one the other day. They took him out of the courtroom. The bailiff said, you better knock that crap off. I'm gonna take you back in there, but one more outburst like that, and you're going to jail. He said, I conditionally accept your offer on proof of claim that my remedy can be considered an outburst. They took him back in. Just testing. You don't know that they're not going to do that. Do not lose the faith. You just hold up. You're not Susie Taylor. You're not Mike, Gordon, Tom, Mary, Jerry, Jack, Larry, Sam. You're not a name. Have a nice day, darling.
All right, thank you.
Bye.
Notice that one of the things we're doing on the conditional acceptance, have you noticed that we're doing things in the negative? Like on proof of claim that not something is happening. Why are we doing that?
What time do we break for lunch?
Got to hit 20 minutes.
2 o'clock?
25.
Okay. Well, we have time to get another little started. Let's have
I understand, but we're asking a question now. Why is it in a negative instead of a positive? Nobody can prove a negative. Now, understand this. See, in
Nobody can prove a
contract-
positive. You can't prove a statement. What you do with that negative is you put the onus probandi, or the burden of proving, onto the other party.
removed
That's
to
the
the other
rules of the
party.
game.
Okay? In civil rule, I think it's 8 or 9 in federal civil rules of procedure. Most states are kind of copying that. It says that if in a pleading is an offer, if in a pleading somebody sets forth a fact by assumption or presumption. Remember how Gordon said this morning, there was a lot of things in what the judge said. He called you the defendant. He said there's charges, yada, yada, yada. There's a lot of assumptions there. They don't have to prove anything to begin with.
As prima facie evidence, remember, it stands as a fact unless refuted.
Okay, in the civil rules of procedure it says that if you do not rebut a fact in a pleading, I mean an offer, it stands as consent of the parties. If you want to rebut it, you could argue it, but if you argue it, you're a debtor. It says what you need to do is you need to put it in a negative averment. And if you rebut the fact by a negative averment, you don't have to prove that you're right. It reverts to the other party now to prove the presumption. So you never want to be in a position of having to prove anything or testify. See, only debtors testify. Creditors never testify in their courts. So if the judge says, raise your hand, he's swearing you in as a debtor. You don't ever want to be in that position in their court because there's such a thing called a debtor's exam where you're sworn in. Have you ever heard of a creditor's exam in their court? Never. Creditors are never sworn in. So you don't want to have to testify. So if there is an offer against you which you don't agree with, don't say, Your Honor, I don't agree with the assumption that I'm a defendant. Because now he's going to say, well, if that's your position, prove you're not the defendant. But if you put in a negative averment, I conditionally accept that I am acting in the role of defendant here today in contradistinction to an accommodation party. It's a negative averment. Now the prosecution or the plaintiff has to prove you're the defendant.
What did we say? She's going into court saying, I conditionally accept these proceedings on proof of claim that I am not here today as the paramount security interest holder. Being the paramount security interest holder gives her status and standing to protect the interest of the debtor because she's a creditor and she's got to protect those.
So if she says, on condition that you can prove that I'm not here as the paramount holder. So if you don't think I'm the creditor, you prove I'm not the creditor. She's not going to prove she is. They're going to have to prove she isn't.
Can
you
they
understand?
prove? See, that's critical. You cannot make statements. We told you what arguing was. If you make statements, if you explain, if you justify, if you discuss. We're not here to discuss.
What did Susie want to do? Discuss whether there was snow up at that cabin or not?
All she needed to tell the clerk is, look, I conditionally accept that the defendant's got to be at the hearing today on proof of claim that up here in Flagstaff, we're not snowed in solid and the defendant can't get there. Well, you have to be here, Mrs. Taylor, and I conditionally accept on proof of claim that there's not so much snow on the ground that it's impossible to get out of here, and on proof of claim that life or limb wouldn't be endangered in any attempt to do such.
Understand.
And on proof of claim that it wouldn't be meant for delay, harassment to reschedule it to next week when the weather clears, enabling me to get down there for the defendant. Any of those could have done the same thing besides just all of her silly statements. But because it was an act of God, the statements worked in that case, okay?
How did Susie Taylor, the defendant, get created? The birth certificate created the fiction, okay? So Susie Taylor is really a trust, correct? Now there's a trustee and a beneficiary. Your straw man is the beneficiary of that birth certificate trust that was created. You're going to see tomorrow that every benefit that you've had in your whole life, food, transportation, entertainment, everything hasn't come to you, the living man or woman. It came to your trust through the straw man. The straw man is the name of that trust. But the body is the corpus in that trust, and that body is named by Susie Taylor too.
When they're asking for the name, Jack, what is it they want?
They want to know who the trustee is that's responsible
What
for
is the
paying
definition
this.
of who? Is it not what? Webster's
correct.
defines who as what or which person or persons. The judge says, what is your name? He wanted to know who you are. I mean, he wanted to know your capacity. And what is the capacity?
Well, the capacity in the Susie Taylor Trust could be the beneficiary who's the debtor looking for a benefit, or it could be Susie Taylor, the trustee, who's here as the creditor to set off the charges. So there's two different roles that theoretically are in that trust.
Or another
beneficiary
name for
or trustee.
Or another name for trustee. If I wanted to say I'm here today as the, remember she said in her opening, and an accommodation party.
It's under Uniform Commercial Code 3-419. An
She's
accommodation party is somebody that pays off someone else's debt with no expectation of a direct benefit in return.
Since Susie Taylor is a stranger to her, as an accommodation party, she's not receiving any benefit. That's their deal. A name belongs to them. That's the fiction world.
See, the benefit is ownership. But ownership in this world is debt, isn't it? So if Susie Taylor is a secured party creditor, why does she want to be an owner of the property belonging to the trust Susie Taylor? A trust splits the title to the property. The beneficiary is the owner, I mean the debtor, and the trustee is the creditor. You want to go in there as the creditor, not as the debtor. Remember, didn't Rockefeller say the rule is own nothing, control everything?
Another word for own is to possess. Is generally when you own a car, is it in the name of your straw man so you think you own it? Big mistake. Wouldn't it be nice? You ought to see it. My boy we have one of his vehicles in a trust name. He says, man, I've been flashed 3 or 4 times, Dad, but I never get any paperwork. They don't issue tickets for trust companies and stuff on these things. Own nothing, control everything. He's the manager of the trust. He gets to drive the truck. And what do you own anyway? It's just a temporary possession. We're leaving here. We ain't taking any of this stuff with us. So quit thinking it's yours.
Who does the government get to charge when a crime is committed? The fiction, which is the beneficiary. So if there's a trust and a straw man isn't behind the trust in terms of the trustee, they can only charge their own entity, their straw man. If your straw man doesn't appear in the trust, they can't charge someone that they don't have control over. You see what the difference is? You got to learn to go private instead of appear publicly.
But it doesn't matter. Jack is telling you you're not a name, and I don't care whether there's a birth certificate behind there or not. A name is a name. It's a capacity. If you give a name, you're screwed. An accommodation party or secured party creditor is the capacity, here merely for the purpose. Remember, what's the subject matter? The parties, the venue, and the subject matter. Let the record show I conditionally accept these proceedings on proof of claim. I'm not here today in the private for this person. There's that, and venue. And now what's the purpose? To continue the public proceedings so I can finish the private administrative process so that substantive and procedural due process and equal protection under the law is applied. Can the judge deny the right of those kinds of things? Absolutely not. That would be a violation of law that he can't get around. So she'll put that into her mantra. What's he going to do? All she got to do is stick with it, and he's got to get her to unstick.
One other element, and then we're going to do some practice until the break, okay? The other element is reservation of rights. How many times have you heard patriots do the UCC 1-207, reservation of rights? Now, it's no longer 1-207. They revised the codes in the mid-2000s here, about 2005 or 6. They changed the number. So if you say, I'm reserving my rights under 1-207, guess what? There isn't a 1-207 anymore, so you come off being an incompetent boob because there isn't anything that you've just stated. It was re-put as 1-308, okay? It says the same thing, but the patriots always only cited half of that statute. They said, I'm here to reserve my rights. But that's not what the statute says. The statute says if you're going to reserve your rights, you can only reserve your rights if you do one thing. What is that one thing you've got to do?
Provide the remedy.
Provide the remedy as requested. So you go into court and they gave you a charging instrument, right? What have they requested you to do?
Provide the remedy.
So you have no rights unless you do what? Pay. Which is why when they charge you, we do a full acceptance, which means I agree to pay. Now I'm reserving my rights. But sir, you're a debtor. You don't have any rights. I conditionally accept that. Proof of claim I'm not the secured party creditor that tendered the full payment, reserving my rights. See, they assume that if you're coming in as the straw man debtor, you can't pay, so you don't have rights. But if you come in as a secured party creditor and you've offered payment, then you do have rights.
That's just prima facie offer, a first offer. If you refute it or rebut it, it doesn't stand. And remember, what is a counter offer? A conditional acceptance is always a counteroffer. A counteroffer is a statement by the offeree, that's the person receiving the offeror makes the offer, a statement by the offeree which has the legal effect of rejecting the offer and proposing a new offer to the offerer.
Okay, so look what happens. They give you that original charging instrument. Do you want to do a full acceptance or a conditional acceptance? You have to do a full. A conditional acceptance says I'm not going to do what you ask me to do. I want to do it my way.
Now you could, there's certain kinds of things, but where Jack's talking about, this is a criminal case. Just endorse the back and hand it over for set-off settlement and closure.
When do you do the conditional acceptance? Once they come back and try to take away your original full acceptance from you. You understand what we just said? See, we said they always charge you and say we want to get paid. You come back and say, I want to pay you on the private side. They go, we don't like that. We want you to pay us on the public side. Then you can conditionally accept their counteroffer to your full offer to pay on the private side. Because if you do a full acceptance to the offer that says we want you to pay on the public side instead of the private side, you've agreed to give up your claim and go back to be a debtor again. You understand? But if you do a conditional acceptance on the first request to pay, you haven't paid. You've objected to payment for some reason in your conditional acceptance. So therefore, under 1308, have you offered performance like they requested? No. So therefore, you have no rights and you fell back into being a debtor. So the first offer is always usually a full acceptance. After that, they're going to try to talk you out of your remedy, to which it's a conditional acceptance, and you keep coming back on your issue to pay them from the private side so you have a remedy. Does that make sense? Okay, let's do some role playing.
All right, let's get court started again here real quick. Thomas, come on up. You want to be the judge? Come on up. We need a court clerk and a defendant and all that good stuff. Ginger, you're going to be the bailiff. So we might have to have you arrest somebody. You wanting some action? Why don't you have a sit down, defendant Benjamin? Bailiff, keep an eye on this guy. And we got Lewis, the court clerk. We got to have one more. Come on, let's go. We'll get around to you two, don't we? We got the prosecutor. We got a judge. Now, you can slip into these roles pretty easily. So this is all for certain reasons. So what you're going to do, we're going to have the state of Thomas versus Benjamin. Case 1, 2, 3. Kevin, you're going to stand up as soon as they call that case and say, hey, Kevin here for the state of Thomas, prosecuting. And when he stands, you better stand right away too, right? And you're going to see, let's see how well you do. So let's call the case.
The state of Thomas versus Kevin, case number 1, 2, 3.
It's
No, we're
versus
not
Benjamin.
prosecuting the prosecutor. We're prosecuting the defendant, Benjamin.
Versus Benjamin. Case
Versus
1, 2.
Benjamin.
Case 1, 2, 3.
Case number 1, 2, 3.
Hold on. What?
Ken, for the state prosecuting.
All right. You better speak up because, hey, Ken's here for the state to prosecute you. Put that up to your mouth. I conditionally accept these proceedings today.
I conditionally accept these proceedings today.
Who are you, sir?
I conditionally accept these proceedings today.
Who are you? What's your role here?
See, this happens.
I conditionally...
Judge Thomas is cutting this man off, so, I might start...
Don't keep going back to the same thing. He cut you off once. Going back to the same thing is just inviting contempt. So he asks you a question, so it's got to be a conditional acceptance, but it's got to kind of respond to what he said. Who are you?
No, I don't even have to respond to him. I'm going to say, excuse me, I'm speaking. When I get done speaking,
Could
Judge
do
Thomas,
that.
you'll get a chance to talk. I conditionally accept these proceedings today on proof of claim that I'm not here. This is why you want to try and be a little bit smooth on this.
Or he could just say, I conditionally accept in the capacity of accommodation party in the matter of such and such. That answered his question, who are you? It was very brief and correct.
I conditionally
But
accept
now
on proof
we got
of
to
claim.
go on, and you got to go back to your introduction.
I conditionally accept on proof of claim I'm not the accommodation party here.
For Benjamin.
For Benjamin.
May I proceed, sir?
See, there's 152,000 ways to do this. The important thing is you're not going to let Judge Thomas, and he did a good job, he just cut him right off.
Okay, watch what's happening here. See, when I told Benjamin to do that, Benjamin, the only thing he has to do here today is act like a creditor, right? That's all he's got to do. Everything else is on the moon. We don't care what the judge's business is. He's either a creditor or a debtor. Do creditors try to assist the court? Yes. So if the judge says, excuse me, sir, who are you? Oh, I'm a creditor. I want to help the court. Let's answer that question. I conditionally accept your question on proof of claim that as an accommodation party for Benjamin, I'm not here to assist this court today. Sir, may I proceed in my introduction? Now, is he acting like a creditor or a debtor? Creditor. Has he made a statement that was not a conditional acceptance? If he makes a statement, is he testified? If he's testifying, is he acting like a debtor or a creditor? Debtor. So he doesn't want to say, I'm Benjamin. He doesn't want to say, I'm an accommodation party. But if he puts it in a conditional acceptance, how did Gordon define a conditional acceptance? It's an alternative issue before the court that's going to solve the problem. What's the problem? The judge wants to know, who am I dealing with? If he says, I conditionally accept that I'm not an accommodation party for Benjamin, Has he assisted the court in resolving the issue? So now he's ready to proceed. Did he testify? No. He's acting consistently like a creditor. At no time has he acted like a debtor so far. That's all he's got to do. Your job isn't to explain to the court, you are here because they asked you to be here. You already told them I'm working on the settlement outside this court. I'm only coming to this hearing to get your acknowledgement that I'm here as a creditor resolving this issue outside the court.
The judge saw this before he came on this thing. Now, sometimes not. Otherwise, he's going to be asking for the charging instrument, but he's here to continue the proceedings, let's say. So
let's say Benjamin says, why are you interrupting me? I'm trying to help you. That's a question. Now, ordinarily, creditors ask questions. Debtors answer questions. But Gordon and I warn everybody we're working with. There are questions that you can come out of your mouth that act like a debtor instead of a creditor because it's not resolving the issue.
Let's
and
see if we
the
can get him in.
easiest one is, Mom says to Junior, take out the trash. And he goes, oh, Mom, why do I have to take out the trash? My little brother gets away with murder. Why don't you make him take out the trash? Is this kid acting like a creditor or a debtor? He's arguing as a debtor, or he's articulating that he doesn't want to do something. Okay? So you got to watch questions.
we prefer you stay with conditional acceptances because you're going to end up in questions that are incorrect, that aren't leading to harmony. Let's see if we can. Now, Benjamin just stood up. The judge is talking. Ken's going to sit down because he's done here. But we're going to start moving this forward. Go ahead, Judge Thomas. This guy just introduced himself. He wants to help and all that good stuff. But we're here for sentencing today.
Mr. Prosecutor, did you give the defendant any documents for this case?
Now, you notice he's standing up whenever he talks to the judge. I'm telling you, when you talk to the judge, stand up. It's protocol. You'll see that the prosecutor does that. That's not a minor thing.
Every time the prosecutor stands up, should he stand up?
No, he's not talking. So Benjamin's sitting down now. He did his thing. Unless this
is operating under Robert's Rules of Procedure. Somebody has been given the floor to speak. When one person has been given the floor to speak, he has the floor until he is done and or surrenders the floor, okay? And if the judge interferes, he's in violation of the Robert's Rules of Order. He knows he is, but what he's doing is testing you to see how you're going to react. A creditor is going to apply Robert's Rules of Procedure in the court so that everybody gets his opportunity and everybody can conduct business and get his business on the record. Okay? The judge is free to do anything he wants to test you out because all he wants to know is Benjamin a creditor or is Benjamin a debtor? That's the only thing that court is doing today. Now, if Benjamin is a creditor, he's going to bring the solution to this problem sooner or later. If he's a debtor, he's delaying, he's obstructing, he's obnoxious, he's harassing, he's causing all kinds of trouble. So Benjamin is not here to solve the world's problems today. Benjamin is here to demonstrate that he understands he is a creditor and he can handle that position. That's it.
Judge?
Mr. Benjamin, could you take your hat off, please?
I conditionally accept to take my head off, Your Honor. If that taking my head off has anything to do with the proceedings that we're here to take care of today.
Well, do you want to discuss that or do you want to go back to your issue?
See, you might want to you shouldn't have come to court with your hat on and a toothpick in your mouth and whatever else. You know, there's protocol. Shouldn't you dress nicely? I would if I were you. A lot of people go in dressed like we are on the street. This is not acceptable court attire. Go in with a shirt and tie.
Not as a creditor.
Not as a creditor. You want to look nice. You want to look neat. If you got long hair, get the thing tied back, cleaned up, whatever. It doesn't matter. They got long-haired attorneys, this and that. That doesn't matter. But go in neat.
You did a good job, Benjamin, because you kind of demurred to his issue, but it could raise a discussion and an argument. So the issue, what you did is like what Gordon was telling Susie before. We're not here informally just to go through some discussion. We're here to conduct our business. So I conditionally accept your offer on proof of claim that is not the issue, the settlement of the case, and has this court not gotten my record of settlement, making your offer moot. Now his offer
Now, at the
was
same
to
time, I'd
decorum.
be taking my hat off.
Yeah,
you know?
and been respectful. Okay.
But I'd be putting something on the record, and then therefore, my business here is concluded. I now move this court, or my business will be concluded. I now move this court to continue these public proceedings for 30 days so that we can resolve the matter privately so that we don't waste valuable public resources.
And there's nothing wrong with coming back and say, forgive me, Your Honor, I did not intend any kind of negative approach to this court or any violation of your rules as far as decorum is concerned, but I conditionally accept your offer now on proof of claim that we don't have the remedy here to resolve this matter, and that being done now, I intend to leave. See, there's nothing wrong for asking for forgiveness in case you have offended the court. Because when you go into somebody else's house or somebody else's business, when in Rome, try to do what Rome wants you to do. If it's merely procedural and it doesn't interfere with your remedy, it's not substantive, that's not a problem. But let's get back, Gordon, to the definition of forgive, I'm sorry, etc. What do they need to know about
We've
that?
talked about this many times. You know, what is like is not the same, for nothing similar is the same. So the words you use in law are very important. I'm sorry means simply, by Webster's definition, inferior, substandard. So when you tell the judge, I'm sorry.
Does that sound like a debtor or a creditor?
Now the judge knows you're sorry
Don't want to
ass,
be that.
you know? You're inferior, you wouldn't be a debtor, and you wouldn't be saying sorry either. So he knows that. Apologize means what? To make a formal defense in speech or writing. I had an attorney when I was in prison. I was doing one for the guards on his divorce. And so I help the guards and inmates alike, and so I'm practicing law. I'm having a lot of fun. And we send off the attorney. They gave money to a year before, and this guy hadn't done any paperwork for this guard. I said, not a problem. The attorney had the $3,500, never filed, never done anything. So we sent a demand notice back. She goes, she wrote back a letter to him and said, I apologize. My mother was sick, made a formal defense in speech or writing. However, I'll now get on it. I'm filing it next week. I'm da-da-da-da-da, you know. So he was kind of happy with that. Forgive. Remember, we told you that all of this stuff has got to do with...
apologize as a debtor because you're making a trial and an argument out of it. And we said to go to trial and argument is only something a debtor does.
If you're sorry, if you apologize, you're a debtor. Now, forgive, we talk about, it's all about claims. In laches, in estoppel, in liens, in the definition of themis, in the definition of forgive, the word claim comes up. It's everywhere. Forgive is to give up all claim to punish or exact penalty for. And I don't say, please forgive me. I might get up and say, forgive my lack of decorum. And I conditionally accept these proceedings any further on proof of claim we're not here, and I now move this court in accordance with the record to continue these proceedings for 30 days, and I've done mine, I do it. When I said forgive me, that wasn't a request, that was a command. Forgive me.
But it means you're bringing the remedy. So forgive is something a creditor does, but it's not, if it is a statement of forgiveness, if you don't bring the remedy, you're not the creditor. So you need two witnesses. Forgive means you're going to be a creditor. Prove it. Oh, because you go back to your issue of presenting your remedy. Now you can be forgiven of your faux pas because now you've brought the remedy as the creditor.
Remember what you're doing in court. You have to prosecute the case. If you don't, the judge is going to do it for you. So he better be on his game because the prosecutor's not going to be on his, so the judge is going to step in for the weaker party.
And to prosecute your case means to come in how? As the accommodation party and creditor to set it off. It doesn't mean you're representing, it doesn't mean you're arguing, it doesn't mean that you're bringing in a novation, just replacing one debt with another. It means you're coming in as the accommodation party creditor to actually zero and terminate that case. And remember, you're coming in as the secured party creditor to that straw man trust, which means you are the creditor. And if you just say, well, that's their straw man is their debtor, and so this has nothing to do with me, I'm out of here, your real problem at that stage of the game is you've abandoned your post as the trustee over that trust. And if you abandon the post on trustee, if you don't make a claim as the trustee having control, then you've abandoned your claim, and the government is going to bring all kinds of hell down on that straw man trust because nobody's at the helm of the vessel.
Why don't we got 5 minutes left. Let's see if we can get through a couple of little things with Benjamin. We'll switch your spots. We'll switch up a little here. We got, no, stay there, Benjamin. The question is, why are we asking for a continuance? The bottom line is we're just going to take that stance for this particular sample, okay?
Either remedy will do because you're going to provide the remedy. So either way you can do it.
We'll
One's
keep it
better
simple.
than another. We'll get into that.
Your mantra is, I conditionally accept on proof of claim. Is there not a request before this court to continue the public proceedings for 30 days? So, Judge, stand up, Benjamin. Rip off your last one again. I conditionally accept these proceedings. I conditionally accept the offer on proof of claim that we're not here, blah, blah, blah. Put it up to your mouth.
I conditionally accept the
offer.
This offer that on proof of claim that
is there not
a
request before the court?
Request for cancellation.
Is there not a request before the court to either adjourn or continue the public proceedings pending? I'll just help him out with this, and we'll see how we do. And you bring Ken into this and let Ken do. We conditionally accept the offer on proof of claim. Is there not a request before the court to continue the public proceedings for 30 days pending completion of the private administrative process? Therefore, my business here will be concluded, and I now move this court to continue the public proceedings for the 30 days so that we can resolve this matter privately so valuable public resources are not wasted, Judge.
What do you say?
Kevin, Mr. Prosecutor, did you give him copies of the indictment? Does he have any indictments? And how did he plead? So,
excuse me, I conditionally accept the offer on proof of claim. Is there not a request before this court to continue these public proceedings pending completion of the start of the ongoing private administrative process? And on proof of claim, is there not a record before this court? Do we not have an agreement on proof of claim that we don't have an agreement with the prosecutor to continue these public proceedings? I now move this court to continue the public proceedings in accordance with the record.
Has there been any agreement with the party? Do you have anything in writing?
Just say no.
Therefore,
we can conditionally accept the offer.
Has pleaded guilty to the
I
crime?
conditionally accept the offer. He says we don't have an agreement on proof of claim. If there's any record in opposition to the record that is before the court. Therefore, my business here will be concluded, and I now move this court in accordance with the record before the court to continue these public proceedings.
See, that's why it's important you have your document in the file of that court. That's the last in. It's in writing, it's a record. So what Gordon, the defendant, just said, see, the prosecutor is always going to say, no, 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 we don't have an agreement. But remember, the only thing that goes on in court is the record in writing. And the defendant, I mean the accommodation party, he's got a record asking for time. The other party hasn't got anything on top of that record.
Now Benjamin just asked a good question. He says, can I walk over and do what I just did? No, that was a sample, ladies and gentlemen. And that is a good question. You don't dare approach that bench without requesting, because that's a threat to the judge and can get you thrown
Your
to the
Honor,
ground.
may I give a copy of the record to the bailiff to bring to you?
That's presuming he doesn't have it. In some cases, like you heard Susie, she's got to get that PSIR thing down there. It's in the mail, but they may not get it Monday, right? Because it's up in Flagstaff, it's snowing, the mail might not do anything, might not even get picked up out of a mailbox till Monday. And it won't be there Monday afternoon, so she needs to carry some copies down with her when she comes into court. Court hasn't started. I'm coming into court with all my stuff. Excuse me, bailiff. I have a package here for the prosecutor, and I have one for the judge, and the other prosecutor, Lewis. So if you could give those to him for the hearing today in about 5 minutes. It starts at 3. I don't have those. Could you give them?
And the bailiff will take it and serve it in the court.
There you go. I don't care if it's served 5 minutes before.
These are courtesy copies because the real service is the thing that is in the mail, but they won't get it for 3 days.
Here's what happened when I went to court here a couple weeks back in Santa Monica. We came in, and you had to check in with the clerk there. So I came up to the clerk just right behind the bar, and I said, I'm here on the so-and-so matter. They said, he says, just a minute, hand me back all the docs. These are in for the judge. He says, no. I said, no problem. So I took them back, and I sat down, looked at these, put our names on it. One of our other guys came in and said, now go take them back to the clerk. So he took them back to the clerk with our names, and he handed it in. The clerk goes, no, you take this. He says, it's okay, give them to the judge, and just walked away. About 60 seconds later, he got up, and he walked up to the podium and put them on the judge's desk. So your politeness, or what you think is being polite, is sometimes stepping into a debtor position. You got to be able to hold your contract. When I gave that, the bailiff is not going to give me any trouble giving package to give to the prosecutor and give to the judge, etc. The clerk might try, but the long and the short is, that's that. We got this. They have a record, and I'm going to simply say, I condition accept on proof of claim. We don't have an agreement with the prosecution today, Judge. I don't care if that stuff just got to the prosecution a minute ago. It doesn't matter to me. Even if it wasn't even put in the mail, it doesn't matter. They got the record. Is there any record in opposition to the record that is before the court? Well, you just put it in 6 seconds ago. How could it be? That ain't not my problem, is it? So anyway, we have a lunch break. Let's wrap it up. We're going to come back and get on with some of this, because you're all going to get it, and we're going to go. We have to pound this a little bit. Yes?
When I spoke with you and Jack a month or two back, I was under the impression that you had to do your mantra before you entered the bar. Is that not correct?
We've changed that up, and we're going to talk about when the mantra and this and that. And we're going to have a little discussion about that, because you're right about that, Kevin. So, hold on. Let's get a mic real quick. Thanks,
You
Judge.
said about the time.
Ooh, you got one. You don't need two.
You said about the time, the stamp on the time. Have you ever had it where the court has not took the stamp or changed the time on it? Because I've seen it before where the court would say, well, we got this February 16th or something, and you put yours on February 17th, and they changed it, and they put theirs on top of yours, on last off.
They'll play games all the time. The purpose of doing that is to get you to argue, because as soon as you argue, you're the debtor. We told you, we don't care what the issue is. The only thing we care about is what kind of role are you going to play as a creditor or debtor. So if the judge wants to make a big issue about the time stamp, actually, if you're serving these documents, the things that are going into the clerk most of the time are notice services until we're ready to come in and
Rarely are
finish
you
our
ever
case.
going to see a judge, you're going to see them playing games with your timestamps. That's so rare.
They might not, but really your timestamp is going in by your third-party server, your notary. And he's more adequate at testifying at times than any of these people are in that court, because your process is outside the court. It's not in the court.
Now, in Susie's case, you heard earlier, she might have a timestamp situation because that PSIR letter has not been responded to, and she's got to do that. Her stuff went in. Now their stuff, they crossed in the mail. She's thinking just whatever's last on top. I don't care, Susie. That's an unanswered deal. We got to deal with that. It's lunchtime.